Crime in Court. My name is Heather, and this is going to be a relatively quick update in the Alec Murdaugh case. So, this is South Carolina versus Alec Murdaugh, and he has already been convicted for the homicides of his wife and son, his youngest son. And this episode, we're going to be talking about the Supreme Court agreeing to hear his motion for a new trial. So, with that in mind, let's begin. So, briefly, I want to go over with you the last filing that was done by this is from the defense. This is the appellant. Sorry, let me shrink myself here. This is the appellant Richard Alexander Murdaugh's motion for certification under Rule 204B. And this is to the Supreme Court of South Carolina. And so basically, they're asking to have their case, they call it certified so that in that case, then it becomes available for the Supreme Court to review it. So in this case, they have allowed his motion here. But before we get into that, I wanted to kind of go over or just remind you because it's been a little while since we went through it, and it was even longer ago when the hearing took place. So um, just really briefly, so Alec Murdaugh came out a few months after the whatchamacallit, after he was convicted with a motion for a new trial, basically alleging, flat out accusing sometimes, Becky Hill of misconduct, which she is most certainly still under investigation. She's got some ethics complaints that are against her that are also there under investigation. It is still an active investigation with the whole jury tampering possibility. However, Judge Toll or Justice Toll, who came in, she was a special judge assigned to rule on this because Judge Newman was retiring and he probably should have recused himself anyways. So Justice Toll, who was a retired justice, came in and did this as, special judge. And she brought in the jurors. She questioned them under oath. Some of them said different things. So we're going to go over what they said just as a reminder. So jurors C, F, L, E, O, Y, W, Q, and K testified that they did not hear Ms. Hill's comment on the merits of the case before the verdict. So they're saying they didn't hear Ms. Hill do or say anything inappropriate. Not to say that she didn't, but they just didn't see it. Juror P testified that he heard Ms. Hill tell jurors, Ms. Hill obviously is the clerk of court, Becky Hill, who they were claiming was doing this jury tampering. So Juror P testified that he heard Ms. Hill tell jurors regarding Mr. Murdaugh's decision to testify in his own defense to, quote, watch his body language. Juror P testified that the comment did not affect his verdict, but is the standard the fact that it was affected or that it was just said in the first place? Because a juror might say, well, it didn't affect me, but they might not know that subconsciously something she said could have affected them. So that's why the just the impropriety of her talking to the jury should warrant the possibility of a new trial. No matter what you think of Alec Murdaugh, no matter how horrible of a person you might think he is, and he's done some horrible things that he's admitted to. He did not admit to the homicides, but he has admitted to many of all of the financial crimes. He's admitted to them and he was sentenced for those. So we are now he's in the process of appealing the homicides. So I don't see him appealing the financial crimes because I do believe he might have even taken a deal so that, if he admitted, then he did a little less time or something. Yeah, I'm not really sure, or they dropped some of the charges. But so he is. I didn't follow the financial stuff all the way through, but I did watch the Murdaugh trial, as did most of us, and was just mesmerized as it unfolded. And then more stuff continued to unfold with this whole jury tampering. So, um, but the standard that Justice Toll used was the whole um, did the comment or interaction affect the verdict? And if it did, then she's supposed to um, grant a new trial. So this person said it did not. Okay, fine. Even if she's using that standard, let's see what the next jurors say. So juror X testified that she heard Ms. Hill comment regarding Mr. Murdaugh's decision to testify in his own defense, and that it was rare for a defendant to testify in a criminal case, and that, quote, this is an epic day. Juror X testified that the comments did not affect her verdict. So again, you can't ever be sure, because once that comment is out there, you can't take it back. And she could subconsciously be like, oh, this is an epic day. Like, what? Oh, I got to watch him more. Or, usually defendants don't testify because they are guilty and they don't want to be caught on the stand. Whatever her thought process is, I don't know. It's a myriad of things that she could be thinking. And it could affect her verdict, even if she claims that it doesn't, or she says it didn't. She might have been subconsciously affected by the comment. But okay, fine. Let's still apply Toll's interpretation of the law that the verdict doesn't have to have been affected. But we have two people that said they heard Ms. Hill say multiple things about him testifying on the stand. So now let's get to Juror Z. Juror Z testified that she heard Ms. Hill comment regarding Mr. Murdaugh's decision to testify in his own defense, to watch Mr. Murdaugh's actions and to watch him closely. Juror Z testified that the comments did affect her verdict. So let's stop right there. Using Justice Toll's own standard, she should have granted a new trial right here. Right here. But no, she didn't. Let's continue on with this. Question. All right. Was your verdict influenced in any way by the communications of the clerk of court in this case? Answer. Yes, ma'am. Question. And how was it influenced? Answer. To me, it felt like she made it seem like he was already guilty. Question. All right. And I understood that's the tenor of the remarks she made. Did that affect your finding of guilty in this case? Answer. Yes, ma'am. The circuit court, so Justice Toll, then examined Juror Z regarding her affidavit attached to Mr. Murdaugh's motion for a new trial, and she affirmed each paragraph therein. So Justice Toll read a paragraph. Did you say this? Do you stand by this? Yes. Okay, great. Because she submitted an affidavit prior to her testifying. So the circuit court then asked, Juror Z, I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question yes. In light of what you said in your affidavit, which is, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Justice Toll says, is that answer that I just read a more accurate statement of how you felt? Mr. Harpootlian says, object to the form, Your Honor, and the court says overruled because she's the one asking the question, so she can just overrule an objection, which is so friggin' stupid. So the juror Z says, yes, ma'am. Question, all right, so do you stand by the affidavit? Answer, yes, ma'am. Question, very good. So is that answer that I just read a more accurate statement of how you felt? And he objects, overruled, yes, ma'am. So it is an accurate statement of how she felt. Not necessarily that one out negates the other. So Justice Toll took it as because she said that the affidavit was correct, that what she said on the stand was not correct, which they could both be correct. She could have been feeling pressure from the jurors, and she could have felt that Becky Hill was making a comment towards Alex's guilt. Both can be true, but for some reason, Justice Toll disregarded that. So this motion is to the Supreme Court about that and trying to get a new trial because of and try to overrule Justice Toll's error. So after I just want to continue on. I know we read through this before, but it's been a while. It's a good reminder. I'm not reading it all. So after Juror Z left the courtroom, Mr. Murdaugh's counsel objected. Mr. Harpootlian says, Your Honor, we objected to the questioning because this juror gave two statements under oath, one in an affidavit and one here to you today. The one here to you today was Becky Hill influenced her verdict. The court says yes. Mr. Harpootlian continues, the one she gave in an affidavit 6 months ago was based on jurors. It could be both. Your Honor picked out the one in the affidavit from 6 months ago and said, is this more accurate statement? This presupposes and suggests to her what she should say, and we believe that this, the juror's testimony, and Your Honor, I'm afraid what you're going to say, well, she said the affidavit was more accurate and what she testified under oath here today, and therefore I'm not going to consider her testimony, and I think that's where we're heading here. I'd ask you to bring her back, explain to her there's nothing wrong with it being both true. The court says, I decline to do that and overrule the objection. Well, then, I cannot stand judges who don't even listen to reason or sense. Anyways, so she doesn't want to look like, no, you're trying to show me or something, show me up. I don't know. By him pointing out that she erred. She did. I believe she erred. She took one statement over another when both statements could be true. So the court is wrong here, in my opinion. Later, during the hearing, Jersey, through her own counsel, provided an affidavit averring, because she couldn't come back. Judge said, nope, I don't want her back in my courtroom, even though she had more to say. And Jersey felt that she had more to say, so she went and had her own attorney provide an affidavit saying, one, I would like to clarify my testimony today. Two, as I testified, I felt influenced to find Mr. Murdaugh guilty by reason of Miss Hill's remarks before I entered the jury room. Three, once deliberations began, as I stated in paragraph 10 of my earlier affidavit, I felt further additional pressure to reach the guilty verdict. Very clear there, stating she originally felt the pressure from Ms. Hill. That was prior to even entering the deliberation room. After that, after deliberating, that's when she felt bullied. Although the circuit court introduced Jersey's pre-hearing affidavit into evidence on its own motion, it refused to allow Jersey's affidavit of that day into evidence or to allow any further testimony from Jersey. So the test or the affidavit that she provided just here that I just read about the order in which things happened, she refused to admit that um, affidavit into evidence. So therefore, the record is unclean. The record is missing vital evidence regarding Jersey's testimony. Ms. Hill testified after the jurors. She denied engaging in. Oh, okay, I don't need to read all that. That's where I'm going to stop. So basically, Jersey's testimony, she said, or not testimony, her verdict is and was influenced by things that Becky Hill said and by other jurors to vote guilty. So that is clearly what she says, and that is why the Supreme Court is going to hear this case. So what we were just reading, obviously, was the appellant record for an appeal or a new case. I'm sorry, or getting a new trial. So South Carolina's Supreme Court justices. This is a Fitz News article regarding this ruling by the Supreme Court. So, South Carolina Supreme Court justices filed an order on Tuesday, August 13th, 2024, agreeing to certify the appeal of Alec Murdaugh's murder, I didn't mean to say that, convictions, homicide convictions, meaning that they will take up the controversial decision reached back in January to deny Murdaugh a new trial on the basis of alleged jury tampering. So they are taking up his his new trial motion. They're going to hear his motion. The ruling from the High Court came a little over a month after the motion to certify, which is what we were just reading from. Murdaugh's appeal was filed by his attorneys Dick Harpootlian, Jim Griffin, and Philip Barber, and Maggie Fox. The motion asked the justices to revisit former South Carolina Chief Justice Jean Toll's decision from January denying Murdaugh a new trial, even though he appeared to have met the high bar that she established in his case, even though federal law appears to be on Murdaugh's side. So, like I said, Judge Toll took this apparently law and she took the standard and she misinterpreted it or misapplied it potentially. She is saying that again, you have to have a witness or a jury who says that the witness or the jury tampering affected their verdict, which we have. But yet, Jean Toll still said, no, I'm not granting a new trial. And she also clearly said in her ruling that she didn't find Becky Hill very credible. Yet, we're still ruling in favor of uh, not. Hold on one second. Dog problems. One second. Sorry. Okay, so Justice Toll's standard is it had to have affected the verdict, and the federal law seems to be on the side of Murdaugh, where it doesn't have to have affected the verdict. It just has to have been proven that there was some kind of comment or inappropriate conversations or whatever. So we've proven, Alec Murdaugh proved that there were at least three jurors who heard Miss Becky say some things that could have been misconstrued as, finding him guilty, which obviously Jersey said that she thought that's the way that Becky Hill wanted it to go, with the guilty verdict. So we know that either standard he proved. So why shouldn't give him a new trial? Baffles me. All right, so and you can hate him all you want, but he still deserves a fair trial and one without all of the financial crimes because literally it was like just compounding. It was too much. Anyways, all right. So according to Murdaugh's attorneys, Toll erred in denying his motion for a new trial, effectively, quote, ruling that South Carolina courts should disregard the binding precedent of the U.S. Supreme Court. So basically, she's saying, let's just ignore the Supreme Court's finding that it doesn't matter if the um, jury changed their verdict or not. All right, so the precedent Remmer versus United States, in which the nation's high court unanimously held that in a criminal case, any tampering with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial. Remmer further stated that the burden rests heavily upon the government to establish that such contact with the jurors was harmless. So the state needs to say, well, this is why these comments were harmless. They have to prove that. The burden is on them, which they didn't prove. Critically, for Murdaugh's case, the U.S. Fourth Circuit Courts of Appeal, which has jurisdiction over South Carolina, has held that Remmer presumption as clearly established federal law. According to Murdaugh's defense, Toll incorrectly ruled that the South Carolina case, State versus Green, directed its counts to ignore the standard established by Remmer. Murdaugh's attorneys have argued Toll misinterpreted and misapplied the Green case to the Murdaugh case. At the conclusion of a 6-week internationally watched trial, a Colleton County jury unanimously found Murdaugh guilty of the graphic homicides of his wife, 52-year-old Maggie Murdaugh, and younger son, 22-year-old Paul Murdaugh, on the family's hunting property near Arlington, South Carolina, on the evening of June 7th, 2021. The erstwhile untouchable scion of one of South Carolina's most prominent legal and political dynasties has also pleaded guilty and been sentenced at the state and federal level for a host of financial crimes, although his federal sentencing is currently being appealed. So his sentencing is being appealed, but he's not appealing his he's probably trying to get some time off or whatever wherever he can for the federal stuff, but he's not going to appeal stating that like he's innocent because he's already been found or he's already admitted to them, so he's likely just appealing for a little time off, I guess, or for better conditions. I don't know. All right, so on September 5th, 2023, 6 months after the guilty verdicts were announced, Murdaugh's attorneys filed a motion which publicly accused former Colleton County Clerk of Court Becky Hill of tampering with the Murdaugh jury. Hill has since resigned from office and found herself in the midst of any number of criminal investigations and ethics investigations, too. So meanwhile, the prosecutors who secured the guilty verdicts against Murdaugh are facing scrutiny for their handling of Hill's case and the broader jury tampering investigations. So do we trust them? We didn't trust them so much in the Murdaugh case when we found out some of their practices and procedures. Anyways, so while the investigation on Hill drags on, Murdaugh's appeal and his bid for a new trial both are continuing to advance in the state court systems. According to the motion filed by Murdaugh's counsel, the state Supreme Court must decide whether the verdict returned after Mr. Murdaugh's internationally televised homicide trial should be overturned due to unprecedented jury tampering by the state official, the former Colleton County Clerk of Court. The legal principle of major importance the defense is asking the court to consider whether it is presumptively prejudicial for a state official to secretly advocate for a guilty verdict through ex parte or one-sided communications with jurors during trial, or whether a defendant having having proven the contacts occurred must also somehow prove that the verdict would have been different at a hypothetical trial in which the surreptitious advocacy did not occur. That's a lot of big words, so let's kind of break it down. So whether um, okay, so is it prejudicial for a state official, someone like a clerk of court, to secretly be advocating or trying to get a guilty verdict from the jurors by doing these one-sided communications that nobody knows about other than her and the jurors? Or should the defendant have to prove that these contacts not only did they happen, but that they also had to have changed the verdict? So basically what we've been saying here this whole time. So in other words, was the tampering itself enough to warrant a new trial, or did Murdaugh's lawyers also need to prove it impacted the outcome of the proceedings? Common sense says that when an elected state official goes into the jury room during a homicide trial to advocate for a guilty verdict because she wants to make money selling books about the guilty verdict, the result should be a mistrial. And she was also at that hearing. Um, Another clerk of court who was brought in from another county and was helping out during the Murdaugh trial told told us in her testimony that Miss Hill wanted a guilty verdict because it would sell more books and because she wanted a lake house. So those were some reasons why Becky may have had a motive to tamper with the jury. And yet, Judge Toll still did not grant a new trial. I mean, how freaking difficult does it have to be? I mean, what do you have to do? What hoops do you have to jump through to get a new trial? If all the things that he's proven here in in that hearing to be true, the things that, Becky was very unreliable. People had a lot of things to say about her and things that she had said about this trial that were out of context or inappropriate or things that she was doing that were considered misconduct. So, yet Alex still didn't get a new trial. So it's just crazy to me. All right. Anyways, while it is important not to read too much into the Supreme Court's decision to grant Murdaugh's motion for certification, the court could have dismissed it outright or deferred action on the request until Murdaugh submitted his broader appeal. So he's still in the appeal process, but this is how he gets it heard, his motion heard for a new trial. The fact that the justices have chosen to hear his arguments is revealing, meaning that they could have just ditched it, they could have said no, but the fact that they want to hear it means there might be some merit to the claims. And like I've been saying, I agree. I think he deserves a new trial based on the things that came out in that hearing. So, what happens now? Murdaugh's attorneys have 30 days to submit their first brief before the Supreme Court. So, that would have been September 13th. So, they had to have submitted that by now, I would think, but I don't know if it's out yet on the docket. Although we are informed it will be submitted today, August 13th. So, I might have to go look for that, their first brief for the Supreme Court. Prosecutors in the Office of Attorney General Alan Wilson will have 30 days from that point, from whenever they receive the brief, to submit their reply. Based on that timeline, the court could schedule oral arguments in this case as soon as December. So that's interesting. We could be hearing in December some oral arguments for this new trial. And this is the Supreme Court's ruling or order here. The state respondent versus Richard Alexander Murdaugh appellant. Order. Appellant asks this court to certify the appeal in appellate case number ending in 576 for review by this court pursuant to Rule 204B. The motion is granted. Because the transcript has been delivered, appellant shall have 30 days from the date of this order to serve and file his initial brief as required by Rule 208. So from this date, when this was filed, August 13th, he has 30 days to respond. So I'm sure they have done that. I just didn't see it anywhere. I'll have to go look for that if it's publicly available. So there you have it. They are going to hear an argument, possibly oral arguments starting in December after all these briefs and everything are filed. I don't know if we're going to see them all if they're going to be public, but the hearings. Oh, I think my phone just fell. Sorry. But hopefully the hearings with Alec Murdaugh for a new trial are going to be public. But I don't know if the briefs are. So I will keep you guys up to date and posted on that. That is all I have for you regarding Alec Murdaugh. So take care, guys. Thanks so much for watching. I will see you in the next one. Please hit the like button on your way out. Bye now.